Okay, thank you.
Okay, yeah, Mr. Lattimore is in the waiting room. I'm bringing him in now. So both of your clients are on.
Thank you. Is there any chance I could briefly go into a waiting room, a breakout room with Mr. Lattimore? I haven't been able to speak with him.
Sure, Mr. Lattimore? Mr. Lattimore? He's on mute. Mr. Lattimore?
Yes, ma'am.
All right, there you are. I'm gonna put you in a breakout room with your attorney, okay?
Yes, ma'am.
So when you see the invite, accept it.
Yes, ma'am.
All right. There you go. Yeah, you wanna see the garage. Finish the garage.
I like that floor. Oh, that's nice.
They're like tiles, they're like rubber, so.
He did the easy way. He did the easy way. Hanging in it and everything, have it on. Yeah.
Now he did,
How much it cost for all those?
Those tiles aren't cheap.
no, they're not.
That's
That's what he said.
But if he had to do it, you might figure this is easier to do.
Now, he did submit and level the floor, but yeah, he put that.
Oh, that's neat. That looks nice. That does look nice. I like that. Oh, man.
I should have known when I got home, it was about done. I was like, oh, okay. Now I see why. Huh? Down here?
Yeah,
Nikki's?
my buddy, he's also a state trooper, you know, all the way.
What was it? His
You know,
birthday or something?
he just came to town, he lives there, so he wanted to see a lot of people. I knew a lot of those guys back in the day, a lot of Yeah, I think
Good morning.
well, let's read it.
Good morning. We're checking in on Blair Arlington.
Okay, I don't have a Blair Arlington on Judge Giles' docket. Did you have a case number I can check for you?
23.
Hold on, give me, hold on. All right, 23.
05752001.
Oh, we come back on Monday.
That's in front of Judge Kevin Robbins today.
All right, thank you.
All right, you're welcome.
She leaves tomorrow. Return to Boston.
Is this one, is this one?
All right, Mr. Martin. Oh, he had, let me see. Oh, here he is. All right. All right, so you ready on both?
Ready on both.
Does it matter which one's first?
No, we can go ahead with Mr. Lattimore's first.
Where you stand? I know she stands.
I got two whenever you guys are ready.
Yeah.
Just in case we, you know, sure.
Yeah.
Look,
Ready when you are.
oh, you're ready? Okay.
36th District Court, City of Detroit City, Michigan is now in session with the Honorable Judge Arnold Giles presiding.
Calling case number 2260741, the people of the state of Michigan versus James Lattimore. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for a probable cause conference.
For your honor, this is Dan Duquette on behalf of people, P number 86690.
And good morning, Judge Giles. Good morning to your staff. Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. James Lattimore. Mr. Lattimore, please turn your camera back on, unmute yourself, and state your full name.
Oh, shit. Oh. Um. Can you see me?
We cannot, but just state your full name. We can hear you.
James
Turn your
Henry.
camera on, Mr. Lattimore. Need to turn your camera on, please.
How do you turn the camera? I'm having trouble. I don't know how to turn my camera back on.
All right. All right, we can go ahead and proceed. But Mr. Lattimore, just so you know, you come, excuse me, when you come in for your exam, or if we have to come back on Zoom, I don't do t-shirts, I don't do sweats. Just wear a shirt with a collar, all right?
Yes, sir.
All right, thank you. Mr. Martin?
Thank you, Judge. Yes, we've received both digital and paper discovery. We're ready to set this for an exam.
July 5th at 9:45.
Your Honor, I could do later on July 5th. I was the one here a couple days ago because I have a conflict earlier that morning. I have one with you on 10:30 that morning. I could do any time after then or a later date.
All right, we set up for 10:45.
10:45. Thank you.
Anything else?
Nothing on Mr. Lattimore. Mr. Lattimore, I'll be in touch with you before July 5th.
Okay, thank you so much.
You're free to go.
All right, thank you.
Next up, we have Mr. Drew.
Calling case number 23-57386, the people of the state of Michigan versus Totez Drew. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is Dan Buchanan on behalf of the people, P number 86690.
And good morning, Judge Giles, Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. Totez Drew. Mr. Drew, please unmute yourself and state your full name.
Totez Drew.
Thank you.
And in this case, we also have full discovery, paper and digital. We are ready to set this for exam. I could do July 5th later in that morning as well.
For 11:15.
Great. That works. Thank you, Judge.
All right, that concludes the hearing. Unless
Thank
there's
you.
anything else.
Nothing further.
All right, thank you.
Thanks, everyone. Mr. Drew, I'll be in touch.
Judge, may I go through quick?
Sure.
For that case yesterday, were you looking for Philip to say that it was a published case?
No, it's got a case.
Okay, yes.
Yeah. You know, but even when they call me a case, you're supposed to be able to give me a copy of it. You know, right now, exactly compare the facts of that case. This one.
Yeah.
Oh, I just don't know why. That some such case that.
Exactly, I know.
Yeah. So that, yeah, you have to, and you have to say that it's just a case that precedent. So that way I know I'm supposed to follow. If you don't, it's like.
Yes, exactly. Yep. Exactly. Okay, sounds good.
I sold, we sold stolen property.
Have you looked at one of these previously?
Yeah. Very briefly, this is like first time reading it. Yeah.
So this is on the chart. And then this is. This is. So this is 1.5. Xfinity. Yeah, Xfinity is fast. Yeah. Now, which two mark? Metro is the city. Morning. What's going on? What do you got? What's your name? Just name one, please.
Did you get in touch with Deanna?
I called and left a message. She
Oh.
went to ask me. Oh, yeah. She's in some of the worst states to live in, that's a weird thing. She's right. Something's good. That can't take this. Yeah. They go with her. Yeah.
Huh? Thought that that's all prison. He's in jail.
Yeah, that's all.
Yeah, he's in
That's all.
prison.
I just put a red thing there.
What about Carter?
Is he supposed to come from somewhere?
Let me check.
I'll look back up because I'm on time still.
Yeah, it's a red on.
One car, it's the car is because they got repaired. No bond, so we had to be said. Some reason, I don't know why, in this case.
This is the OIC on 12, this hand up. I mean, back on that. Oh, great.
Thank you. All right. Okay. I have on the side. No, okay. Case, man, it's a 2012.
Yeah, yeah, I'm sure.
Just see so we go down.
Nice. Mr. Hancock, check me.
Yeah, I see Clark Baggett is, that's a long case, that's 2012.
Yeah.
Mr. Hancock's attorney check this.
Not yet. That's those attorney check me.
We had officers for that.
We have an officer for Hancock.
Yeah, we got two.
Oh, yeah, yes.
Carter and that's. So.
My husband told me 7 in a car accident.
The only thing was from the.
So.
711. So I just thought I was taking it out.
Right, we did it was like last minute, really, not. Oh, here she is. Here's the hour.
No, I get it. For clients. We're doing business.
Damn.
We're doing this last piece.
I think he does.
Good morning, Ms. Diallo.
Good morning. I think my client might be there in person.
Yep, we just brought him in. He's been here.
Okay. Yeah, I was gonna walk over there, but I'm caught over here at Frank Murphy, so sorry.
Okay. You ready, Kim? Calling case number 22-60292, the people of the state of Michigan versus Michael Bates. Defendant is charged with count 1, first-degree arson. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Judge, good morning to you and your staff, Lillian Diallo, P52036, on behalf of Michael Bates, who is physically present in the courtroom.
Thank you. Good morning. Mr. Bates, can you state your name for the record?
Michael Bates.
Thank you. All right. Ms. Gallo will set the matter for exam.
Yes, please.
July 6th at 10:30.
Sorry, what time, Judge? July 6th?
July 6th at 10:30.
Oh, yeah, that's a great day. Thank you so much, Judge. And it's going to be in person as well, Mr. Bates. And I don't know if I have paper discovery. I don't know if I have digital discovery. So if there's any digital, please send it over.
Yeah, I will
That's
double
okay.
check.
Okay. And Judge, Mr. Bates,
Order.
I'm sorry, Mr.
You can send it for the discovery. That way, if you don't get it, I can act on it.
Oh, thank you, Judge. And Mr. Bates wants me to address his bond conditions. Is that correct, Mr. Bates?
Yes, I did go to work.
So, Judge, yes, Mr. Bates has the ability to go to work. He is employed. I think he's on house arrest and he has the documentation and paperwork with him. So if you could amend his bond conditions so that he can work, that's what you wanted, right, Mr. Bates?
Yes, yes, I'm gonna tell her. I need to be back to house.
We'll show it to the prosecutor person. You don't work specific hours? You don't work specific hours?
Yes, I work just 2 days a week. I'm a retiree.
Well, this doesn't say that. This says you're on call.
Yeah, that's what it said. It's 2 days a week. I'm on call.
Well, I'm not gonna you know, that's, if I do that, I'm just basically removing your tether then. And I'm not gonna do that at this point. I need to know, you know, when you work. And then I could enter an order that says that you are working. Or you are in an order saying that, you can go. But he's gonna end up having to provide, every time he gets a call to go into work, he's gonna have to provide that documentation to, the sheriff. What do you want me to do? Yeah.
Okay, Judge, well, I heard you. Mr. Bates, I think he understands, right, Mr. Bates?
Yes, I understand. I need to go back and get the dates that or the week that I work.
Right.
Well, yeah, I know the dates that you're going to work,
Right.
you know, that way we can, like if it's every Tuesday or Thursday, or if they know in advance, for the next couple of weeks.
Okay.
And, you know, I'll enter order for that, but I gotta have something.
Okay, so
This says 24-hour. Any
so,
day.
I'm just wondering.
Okay.
Can I bring the information back to you, or what do I take?
I'll bring it back to the attorney and she can get it to the court and, she can zoom in and I'll deal with it.
Okay.
Thank you so much, Judge. You and your staff have a wonderful day.
All right, thank you.
And take care.
Sure.
Morning, Judge. How you doing?
Good to see you.
Yeah, despite this morning that stuff out there.
Oh.
Gotta wear a mask outside now. Just when I thought it was done with that. Back in it.
That fire's gonna be around for another 20 years.
So I can't even go and enjoy the 4th of July at the park.
You're gonna have a lot of days like that.
That's bad.
You know, which way the wind's blowing.
Yeah, so I just wanted to let you know. She's saying stuff about for you in the evening so that you see what's going on.
Okay. That over with.
I don't know, that, I think he was IT or something.
Oh,
He the IT person, so he must be, they was gonna go with him and try to get the CTN. So, anything I sent you one yesterday. She didn't have it on me.
Okay.
But I just sent you one, so she let the staff know to try to figure this problem out. Okay?
All right.
All right.
All right,
Y'all have a
thank
good
you.
day, okay? Put your mask on.
Okay.
Yeah, I heard this.
Yes, thank you. Okay. Thank you. Hi, how are you?
It just automatically just happens.
I was confused.
There. That's that issue of that case we had yesterday, no attorney. They still say they don't have no CTN.
And we don't know if they don't have a attorney. I don't, nobody over, I'm just like.
So
I gotta have a train, I keep getting locked up.
So I told, Ms. Knight that, she said, they probably won't get paid though.
Well,
let me call.
when the show calls somebody over at the Third Circuit, I mean, they got to do their job.
Right, and it's not on us, I mean, that got nothing to do with us. I just, yeah, I just seen it, you want like 12 dollars.
No worries.
Yes. Yeah. What about? Yeah. Yeah. Which is different, but
Well, I was told that. Yeah.
I'm sure radio is, I'm not sure. It's just, it's not a time long.
It's pretty easy. She threw it on. He's in jail in P.
What about the Carter?
Oh, this is, stolen. It's a charge of Thursdays. Oh, yeah, felon possession. Oh, this is where he, I have the other way. Driving, he had a license plate with registration of on his own station, he broke in. Stolen property, which, there's no known answer. Home over, vehicle stolen, unless, actually, when you come to.
She said, yeah. She said, yeah. They will pay. If you decide to.
That's all. Yeah. It's crazy.
I think I have to argue something.
Yeah.
You take them or we find them.
That's right.
All right, here you go, Alex.
All right, I'm coming.
Is it 5?
Yeah.
Okay.
Thank you very much.
Oh, I'm sorry. I'm sorry, Judge, I forgot to tell you. The attorney on Hancock, she did call. She said she was stuck in traffic on Gratiot. She'd be 10 minutes late. I forgot she did call.
Okay.
Is that the handout?
Yeah. You doing Hancock, man?
Say that because I literally have matters and.
NBS is in way, that should be the slogan. What's that?
All right, she's here.
But my client is not. Here's what you're saying. Okay, thank you.
cases that work for you.
Yeah.
Are we ready? Ready, sir?
Yes.
Stand up, please.
You ready, Kim? Calling case number 2357322, the people of the state of Michigan versus Desmond Hancock. Defendant is charged with count 1, police officer assaulting, resisting, obstructing. Count 2, disturbing the peace. This matter is scheduled for exam.
Morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
And good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service on behalf of Mr. Hancock, P86432. Mr. Hancock, would you please state your name for the record?
Desmond Hancock.
The people are prepared to proceed.
Your Honor, may I address bond prior to?
No.
No.
No. You can review the exam.
May I do it after the exam?
Yeah,
Okay, thank you.
I'm not gonna do it before.
The people would call Officer Jenkins to the stand.
Off of Jenkins?
That's correct. Jenkins with an S.
Larry?
Yes.
J-E-N-I.
Yes.
Swear, Judge, swear in.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Put the door towards you. Seat, please.
Larry Jenkins.
Officer Jenkins, please state your full name for the record, please.
Larry Jenkins,
And where are you currently employed?
City of Detroit Police Department,
And in what capacity are you employed there?
police officer.
And were you employed in that capacity on June 12th of 2023?
Yes,
Did your duties as a Detroit police officer take you to the address of 3435 Second Avenue around 4 p.m.?
yes,
Okay, is that in the city of Detroit, County of Wayne?
yes.
Okay, and what is there?
It's a green light location for a market,
Okay, what were you doing at that location at that date and time?
conducting a special attention.
Okay, so were you solo at the time? Did you have partners?
I was solo.
Okay, and were you in a vehicle or on foot?
I was in a vehicle.
Could you describe the vehicle that you were in?
It was a semi-marked vehicle. It was black with black glitter.
Okay, what were you wearing at the time?
I was wearing my full Class B uniform.
What observations did you make at that address around 4 p.m. on that date?
I observed a vehicle parked on People Street, and I also observed 2 males on the side of the vehicle, apparently drinking out of solo cups.
Okay, so let's stop there and dig down on this a little bit. So you observed this vehicle first and foremost.
Yes,
There are 2 males outside of this vehicle drinking out of solo cups as you described them?
yes,
Okay, is there anyone in the vehicle?
yes, there's 2 people inside the vehicle.
Okay, and where are they positioned within this vehicle?
Driver's seat and passenger seat.
In the front for both?
Yes,
Okay, very good. So you see this vehicle, you see these two individuals drinking out of solo cups next to this vehicle. What investigative steps do you take next, if any?
I ran a vehicle, through Lee,
Okay, and when you ran that vehicle through Lee, what did you discover?
that the insurance, that the vehicle did not have valid insurance and that the plates were expired.
Okay, and is that takeable offense?
Yes,
Okay, so you discovered that this vehicle does not have valid insurance and that the plates are expired. What steps do you take next?
then spin my vehicle around and, conducted a traffic stop.
So you conduct a traffic stop on this vehicle, and on your approach to this vehicle, what happens?
Mr. Desmond Hancock,
Let me stop you there, but before you give the name, could you explain who is he in this scene?
the individual standing on the sidewalk.
Okay, one of the two individuals standing on the sidewalk.
Yes.
Okay, now, do you recognize that individual sitting in the courtroom here today?
Yes.
Okay, could you please point to him and identify him by an article of clothing that he's wearing?
And a plaid shirt.
Thank you, and Your Honor, may the record reflect he's identified defendant in this case. Okay, so you approach this vehicle, and how does Mr. Hancock respond?
He walks towards me and I asked him, "What's up, man?" He said, "What's up?" And I asked him to stand on the sidewalk and he said he wasn't standing on nothing.
Okay, so at this point, you've asked him to stand on the sidewalk, he declines to do so. What does he do next?
I repeated, for him to stand on the sidewalk and he yells the words "no," and that's why I was there.
Okay, so what did you respond when he asked why you were there?
I told him I was here to, talk to the driver. And then he began to approach me and I, deployed my taser.
Now, you say deploy your taser, could you explain what that means to me?
It's just drawing on my taser and pointing it at the individual.
Okay, did you actually utilize that taser on Mr. Hancock at that time?
No.
Okay, so you pointed at the taser at Mr. Hancock, why did you do that?
Slow down, you are talking very fast.
My apologies, Your Honor, I just finished up a cup of coffee. So you point your individual at, you point your taser at Mr. Hancock. What does he do in response to this?
He stated that, you're not gonna tase me and that he would, spit the shit out of me multiple times.
He would what? Could you repeat it?
Spit the shit out of me multiple times.
You would do what?
Spit the shit out of me?
Spit?
Yes.
So at this point, what does he do then? What does Mr. Hancock do after that?
He begins to walk towards me with his fist clenched.
Okay. After walking towards you with his fist clenched, what happens next?
His brother, the other individual that was standing outside the car, begins to pull him away from the location.
Okay.
Okay, I'll move back just a little bit, 'cause
Yeah.
I'm not hearing anything you're saying.
Oh, sorry.
Because too
Sorry.
close to the.
Yeah, right there. You're popping the mic a little bit.
Okay.
So the individual that you identified as his brother, was this the other person standing on the sidewalk with Mr. Hancock?
Yes.
Okay. So he pulls him away. Did you observe any other behavior exhibited by Mr. Hancock on this day?
Yes.
Okay. What else did he do?
As he was pulling him away, he was pushing his brother away to come back towards me.
Okay. Did you place Mr. Hancock under arrest at any point?
No, not at that time.
Okay. Did you, on this date and time, ever place him under arrest?
Yes.
And why did you do that?
For assaulting someone.
Okay. You say for assaulting someone, so take me back a little bit. He's been pulled back by his brother.
Yes.
From being pulled back by his brother, when is it that he assaults someone? Is this immediately after? Is this 30 minutes later? When is this?
This is about 5 minutes later after he's pulled away from his brother.
Okay, so you witnessed him, you described assault somebody. Could you give me, is he still by the vehicle at this point? Has he moved somewhere else?
He's moved to the parking lot of the grocery farm market.
Okay, so he's still at this address.
Yes.
And what do you witness him do specifically?
Witnessed him stand on the driver's side of the vehicle and push the individual in the driver's seat multiple times.
Okay, back up just a little bit here. You see him at a vehicle
Yes.
and there's someone in this vehicle.
Yes.
Where are they sitting in this vehicle?
In the driver's seat.
They're sitting in the vehicle and you see him, you describe it as punch.
Yes.
Okay, so in response to observing this behavior, what steps do you take?
I then get out of my vehicle and approach Mr. Hancock.
On your approach to Mr. Hancock for the second time, what does he do?
He begins to walk away.
Okay, and what do you say to that, if anything?
I said, stop, I'll tase you. And then I told him to come here now.
Okay, did he respond to those commands?
No, he did not.
What behavior did he do?
I continued to walk away.
Okay, so do you eventually place him in handcuffs?
I eventually grabbed both of his hands and then he pulled away from me.
You say pulled away from you. Could
Yes.
you describe that? So you have, are you behind him at this time?
I'm behind the individual.
Okay, so he pulls away as if to get away from you.
Yes, correct.
Oh, no,
I apologize, Your Honor, that was leading.
thank you. Let's get it from him and not you.
He pulls in the opposite direction that you are standing.
Correct.
Nothing further at this time, Your Honor.
Are you familiar with Detroit Police Department's policies on use of force?
Yes.
So you're aware that tasing someone is a use of force?
Yes, correct.
And you're aware that it's only authorized when it is objectively reasonable
Yes.
in the light of known circumstances at the time?
Yes.
These include the seriousness of the crime,
Yes.
the level of threat,
Yes.
and the level of resistance,
Correct.
and the danger to the community.
Yes.
And use of force is only warranted after you attempt other means to address the situation.
And then it all depends.
Okay, but you can use such techniques as de-escalation techniques.
Correct.
So referring to the incident, at some point, Mr. Hancock was arguing with someone in a white vehicle.
I wouldn't say argument, he was assaulting someone.
Okay, so you've seen him assault him. What you said, he punching him?
Yes, punching and pulling him out of the vehicle.
Okay, and this is when you approached him?
Yes.
And, just to make the record clear, it was not his brother, it was his cousin that he was with. So while his cousin was pulling him away from the vehicle, you witnessed this.
Yes.
And then you pulled out your taser for the second time.
Yes.
And you stated, I'm going to F and tase you.
Yes, correct.
You then told Mr. Hancock to stop.
Yes.
And at this point, Mr. Hancock started walking away,
Correct.
and you told him to come here.
Correct.
And again, you told him that you tased him.
Yes.
And then you grabbed his arms from behind,
Correct.
and he turned around to inquire as to what you were doing.
He violently pushed away.
Okay, and then this is when you tased him.
That's when he turned around and pushed me. And then I deployed my taser and tased him.
Okay. So isn't it true that per,
He pushed you?
Correct. Right.
isn't it true that per DPD's policy, officers should allow an individual time and opportunity to submit to verbal commands before force is used?
Yes.
And yet from the moment you approached Mr. Hancock to the moment you tased him, only 20 seconds had passed.
Correct.
Were you wearing a body camera at the time of the incident?
Yes.
If I were to show you that, would you be able to recognize it?
Yes.
Your
Hold on.
Honor, I
Hold
have
on, give
to,
me offer proof.
the offer of proof is just going to reiterate the
I
sequence
don't
of
need to
events.
reiterate, you got it from him.
Okay,
You got it on the record, why do I need to see it on this video? He's agreed with everything you've asked him.
this is true, Your Honor. I was just trying to make a record to, if for any reason I need to reference it later, I could.
You can produce it later. I mean, I don't need to see it. If I've already got it all from him.
Understood,
If
Your
you're
Honor.
not showing me anything different, then I don't need to see it. If he has said something different than what you're saying is in the video, then I'll look at it. But from my understanding, that's not the case.
Understood,
right.
yes, that is correct.
All right.
And you stated that you witnessed him assaulting someone
Yes.
after
Well,
you,
We need to rephrase that.
sorry.
An
You-
assaulting someone
This
is a legal determination that I make. I
Correct.
call someone punching someone.
You've seen someone punching someone. You've seen him punching someone.
Correct.
After you had tased Mr. Hancock, that vehicle had already left.
Correct.
Okay, no further questions, Your Honor.
No redirecting people, Your Honor.
All right, thank you.
Thank you.
And Your Honor, the people would move to bind over on all counts.
Any other witnesses?
No further witnesses, Your Honor, my apologies.
All right, defense have any witness?
No, Your Honor.
All right, now,
And Your Honor, the people would move to bind over on all counts for zero argument this time.
no,
Certainly. So in this instance, we have two separate occurrences within a 5-minute span. So Officer Jenkins approaches this vehicle after seeing through lean, there was an expired tag.
I don't care about that. The vehicle was parked, so it had an expired tag, it didn't have insurance, I don't care. It doesn't matter. He wasn't even in the vehicle, so that has nothing to do with this case,
Certainly.
nothing. Other than that's why other than put himself in that area. Okay, so we can skip all that and get to the main meat of the charges.
Yeah. So 5 minutes later, he does observe Mr. Hancock striking somebody with, well, he describes it as a punch, so presumably a closed fist he's striking him with. So at this stage, he approaches Mr. Hancock and attempts to place him in handcuffs, pending further investigation of why he's striking somebody.
Further investigation, what is it to investigate? The person left.
That's true, Your Honor. It could have been the case that, there was a situation that could have been ongoing, maybe that person had threatened somebody.
Allegedly, oh, come on, now, we're gonna add facts to this? You know, I don't mind if you add it based on what's there, but we're not gonna make it up.
Certainly.
All right,
Sure.
so
Well,
we have to go
it's-
by what's there. Hold on, let me
Yeah.
get to where I'm getting, and then you could address that. This guy, the guy in the car who allegedly is his cousin, leaves. There are no charges related to that. What piece was he disturbing? And why did he have to put his hands on him?
Your Honor, the piece he was disturbing at that time, at the time of the second incident would be the strike, I would argue.
The guy's gone. He knows there's a police officer right there, and he leaves.
Certainly, Your
And
Honor.
obviously, the police did nothing to contact him to see if he wanted to press charges, correct?
Correct.
We don't have
Well, and then the only other, and completely discounting the vehicle incident from the beginning, if that vehicle wasn't there and Officer Jenkins was simply stepping out of his patrol vehicle, just stepping out of his patrol vehicle, at that stage, Mr. Hancock did approach him.
I'm saying if he was, he wasn't.
Sure, but Mr. Hancock did.
We don't have a if, we don't have a situation where we don't know why the officer was there. We know exactly why he was there. You know, he went to investigate a vehicle, to do a traffic stop on a vehicle that was already stopped, already parked, not moving. He never saw it moving. So that's not a traffic stop. Traffic stop is when a vehicle has been moving.
That's correct, Your Honor. And the only other thing that I would offer in connection to this event, there were two people drinking out of red Solo cups, which could indicate that the car was.
Oh, no, we're not even going there. That could be juice, that could be pot, that could be alcohol, that could be a 1,000 different things. But the officer didn't investigate that. He didn't walk up to them and say, you know, what's in the cup? You know, he didn't do anything with that cup. Matter of fact, he left that completely alone. Right?
Correct.
Because he walked away from that. He walked away from the car that he was allegedly investigating too. He didn't give that person a ticket. He didn't do anything. He left and went back in his car. Correct?
That's correct, Your Honor.
So we got an alleged traffic stop that nothing happens. Now, we don't know the relationship between the cousin and the defendant. Obviously, he didn't, you know, it's not to the point that he wanted to press charges or do anything.
Hmm.
Correct? Because that hasn't happened.
There's nothing in the record to reflect that, no.
Why are we?
And Your Honor, given that the people make no motion at this time.
Right. Now it's dismissed.
Yeah, I apologize, yeah. Okay, let's see what box you want me to check. There you are.
Oh. It would be insufficient evidence.
What if-
right?
okay.
Right.
This is it, 29.
Yes, the 29.
Actually, it's like no problem, so there's a motion to swing it over.
Yeah, that's what I'm saying, she ended up not motioning. Yeah.
Yeah, well, they didn't. Ultimately,
Yes.
they moved to bind it over.
Thank you.
You're welcome. Yes,
See, come.
yes. I guess it's there, yeah. I guess that's what he was getting at. I just, I'm back for that.
Is he on the tether?
He is on the tether, yes. Thank you. Yeah. And he can just go down to Dickerson, like,
Free to
right
go.
away.
With this copy in the ROA.
Gotta work with what you got.
Yeah.
No. I can understand this.
When I talked to him after the fact just now, it is a mistake on my part. Mistake is, I don't know.
What it is, but the way he was acting, but no, that came out.
No, that was a mistake on my part. I didn't see that guy.
Well, that was a bit.
Coffee.
That, you know, that's. It's like,
Yeah.
you know, just, you know, you're going at machine gun speed,
Yeah.
you know, and you don't miss something. So it was a bit, you know, because if you slow it, I said this, you don't know nothing. You know, that's That's by simple. Because we don't know it, we don't know it. So when you ask a question about it, it gives you an answer. That question doesn't quite seem right. And you know not to go to that next step you were going to.
Don't go to that.
Yeah, let's deal with that first. Then we go to that. You know, and that just slow down, and that will help you. The fact that if you don't know anything, and that way, because I don't.
Right.
You know, I don't know what they say. I go strictly by what they say. You want me to understand it then? Yeah. You want me to know what you know? Yeah.
I wrote it out, what I told. Guys.
Yeah. Huh?
Yeah, today and tomorrow.
This what? That's why.
Morgan, he's a country artist. Yeah,
That's all. That's for you. Got tickets?
Yeah, I have a sweet.
Oh, shit.
Tomorrow. My father, I'm really lucky, my father.
Awesome.
Yes. You know, Mom's
Very
day off.
well. Take care.
Thanks, guys. Have a good day. Have a good day, Your Honor.
Take care now.
You can't go.
I'm already going today, going to Walmart.
Oh, you want, well, do you got a suite?
We're saying that. Hey, well, she got the problem. I'm to the state level with mine. So that's what I say to that. Yeah. And that means I'm not eating good for about 2 weeks though. Oh, no, I won't. I can't. I won't do that.
Sorry, Carson, I don't know if they got an ETA on ESCO.
Well, I can tell it. But they said it's going to take, a month, so. Yeah, 2 trips, a lot of people. Yeah. Well, I'm gonna see what I can do. Don't wait on each other. From Miss Carson. See you
Darren, give,
Oh, two were.
And then bring them?
Oh, that's what it is. You have some. No, we'll show you. I can.
Yeah, mine is mine. I'm working with Danielle this week, but so we got this.
Time.
Yes. I'm not Alex.
So next week, just all right. I guess.
Yeah.
That's right. It's like these guys. No professionals. Yes.
I have some information now.
We won't stipulate, but.
What it costs. We need to get. Yeah.
You wouldn't have? No, I try not to.
That was good.
No.
So. And then even though. It's older. Yeah, it's, you get these reviews because. Yeah. They show pictures.
All right, who's up? Next.
So, did he get? So, I tried to, tell him that one. He says, okay.
I think we're doing. Where's she going? Dan, are you doing Carter?
No, I'm doing Van Blarden and Montgomery.
Okay, who's doing Carter, Alex? Okay, I think we're gonna do Carter. Cause, we don't have Esco. Courtroom 2. I don't understand. Uh-huh.
It's a transport unit.
Okay, yeah, she.
They've been gone, so they should be.
Okay. All right. She did her.
They should be. She did get the cards.
Mary, can you tell them to bring them so we can join?
What we doing now?
Tell them to come on in.
Well, we'll go right now, right now.
Thank you. Appreciate it.
What we doing? My client's not here. If the court's gonna hold an exam, I'm gonna ask, I make sure to be here at 9, just in case, because I know how early the court is. But I just have a quick plea over there. If the court's about to hold another exam, I'd ask.
Go ahead. Go ahead.
Thank you, I appreciate it.
Yeah, sorry. This is a whole, they got. They don't check in.
I hope you're going to get, oh, I think, time with the new leader. So we got Carter. All right. Parties ready on DeJuan Carter? Calling case number 2357145, the people of the state of Michigan versus DeJuan Carter. Defendant is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, ammunition, possession by a felon. Count 3, weapons carrying concealed. Count 4, weapons, felony, firearm. Count 5, weapons, felony, firearm. Habitual offender, third notice. This matter is scheduled for exam.
Good morning, Judge. I was swearing on behalf of the people. P number P86590.
Good morning, Your Honor. Attorney Sahar Baraj appearing on behalf of Mr. Delam Carter, who appears in person to my right. Mr. Carter, can you please state your name for the record?
Juan Mario Cody.
Thank you. All right, ready to proceed?
The people are ready to proceed. Before I call my first witness, I have shown defense counsel the registered action pursuant to MCL 766.11B. I'd like to present this to the court of the defendant's prior record where he pled guilty to armed robbery.
Your Honor, the rule require a certified record of conviction. What the prosecutor has showed me is a certified record of a register of actions. So we just object to that.
So we just what, counsel?
We object to that.
Well, the rule doesn't necessarily require a certified record of conviction. It's just required a certified record. I have to have something that shows that it actually happened. It could be a conviction. It could be a sentencing memorandum. I mean, I'm not a memorandum. It could be a sentencing. It could be the register of action. Doesn't matter. So court will accept it. Let me see it.
May I approach?
Yes.
Hey, counsel, can I get your number, please?
85175.
Right.
The people call their first witness Eli Arkin,
A civilian witness.
police officer Eli Arkin.
ARKAN.
ARKAN is Nancy. For Leslie.
ELIA.
Speak to us for your.
You swear or affirm the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Put the door towards you. Have a seat, please.
Good morning. Please state your name again for the record.
My name is Trooper Archon Eli,
And where do you work at?
Metro South Michigan State Police.
And what is your job?
I'm a Michigan State Police Trooper.
And were you working in this capacity on 05/30/2023?
Yes,
And did your work bring you to Davison Road, Livernois, Detroit, Michigan?
yes,
And that's in Detroit, County of Wayne?
yes.
And were you driving in a vehicle that day?
Yes, I was a passenger. My partner was Trooper Smith, he was driving.
And when you were in the vehicle, what did you observe?
I observed, I can't remember the specific vehicle. I know it was either Tahoe or Suburban. The driver was wearing a white shirt. I did see him not wearing a seatbelt.
And when you didn't see him wearing a seatbelt, what did you do next? What happened next?
Me and my partner both were on the same page with it. So as my partner had pulled into a gas station, we're waiting for the vehicle to pass so we can conduct a traffic stop.
When you conducted the traffic stop, what happened next?
I saw the driver of the vehicle exit the vehicle.
Do you see the driver of the vehicle in the courtroom today?
I do.
Can you point to a piece of clothing that they're wearing?
Yes, he's sitting right over there. He's wearing green overalls.
Please let the record reflect that the witness has identified the defendant. So let's go back to the vehicle. When you approach the vehicle,
He didn't say he approached the vehicle. He didn't say he conducted a traffic stop. He said he saw the driver leave the vehicle. That's what we have.
Did you notice or observe anything about the defendant's vehicle prior to your partner pulling into where you guys pulled into?
So we had pulled into the gas station. We were expecting the vehicle to pass us in the gas station. We already observed the infraction without wearing the seatbelt. We were waiting for the vehicle to pass us. The vehicle had been pulled in to a gas pump in the gas station where we were. So when my partner had turned around, we also observed the vehicle did not have a license plate.
So when you observed it didn't have the license plate, what did you do next?
My partner had conducted a traffic stop, and we both exited our vehicles, the patrol vehicle.
And then when you exited your patrol vehicle, what happened next?
I observed the driver exit the driver door.
And when you observed that, what happened next?
My partner made contact with him.
And from that contact, what action did you do?
I know my partner did ask a couple questions. Within the questions that my partner had asked, I heard the defendant state that he had a gun in the vehicle.
And when you heard he said that he had a gun in the vehicle, what did you do?
Well, the defendant had stated somewhere on the lines that he had a gun in the vehicle and his girlfriend had a CPO. So my actions were to go make sure there was nobody else in the vehicle, but I was expecting there to be another occupant since somebody had a CPO. I went around the vehicle and I didn't observe anybody else in the vehicle.
So the defendant was the only person in the vehicle?
Yes.
And what did you do with the, did you do anything with the vehicle?
I did search the vehicle, yes.
Did you recover anything?
I did, a firearm.
And what did you do with that firearm?
I seized it, took it, and unloaded it, took it into property.
No further questions.
Good morning, Trooper Arson. If at any moment in time you don't understand any of my questions, let me know and I'll try my best to rephrase them for you, okay?
Okay.
I want to first talk about the reason you stopped Mr. Carter that night, okay? According to you, Mr. Carter was stopped for traffic related infractions, correct?
Yes.
You saw that Mr. Carter was driving a vehicle that night,
Yes.
and as he was sitting in the driver's seat, you didn't see a seatbelt.
Yes.
And then you also realized that the car that he was in did not have registration plates, correct?
Yes.
And you were seated inside the trooper car, correct?
Yes.
And you guys had already pulled into the gas station parking lot, right?
Yes.
Mr. Carter was not there yet,
No.
and then Mr. Carter drives the car into the parking lot,
Yes.
and then that's when you guys move your squad car around?
Yes.
And it's your testimony that it's at that point in time you realize that his car does not have registration plates?
This is true.
So you activate your light,
I did not.
I didn't hear the answer.
he said that is
Please.
true.
Yes, that's true.
Okay,
That's-
go ahead, all right.
Your partner activated the light,
Yes.
you exited your squad car,
Yes.
and then you also stated on direct that Mr. Carter had exited his car, correct?
Yes.
And when Mr. Carter got out of the car, his hands are up in the air.
I don't recall.
Well, Mr. Carter's compliant, correct?
Yes.
He doesn't give you any issues.
No.
He doesn't resist.
No.
He answers your questions
Yes.
and your partner's questions,
Yes.
and he walks over to where you guys are at, correct?
I didn't make initial contact with him, so I can't really answer that. I don't recall.
Well, you and your partner exited the squad car at the same time, correct?
Yes.
And you were standing right next to your partner, correct?
I don't recall.
What would seeing your body worn camera on that night refresh your memory?
Sure.
What's the relevance? What difference does it make?
To show his actions for what he did once the
Talk about
defendant.
his actions. There's no dispute regarding his actions.
Well, right now, my question is regarding whether or not Mr. Carter was near, because the line of question, Your Honor, if I may offer, is, Mr. Carter was taken into custody and detained away from his vehicle and not standing next to his vehicle. So when I asked the trooper, I apologize.
What difference does that make?
Because he then searched the car. And what he just testified to was only having stopped Mr. Carter for traffic-related offenses, and according to Arizona began. Evidence of the crime scene.
I don't know, Arizona began or whatever you said. You want to quote a case to me? You give me a full quote and you give me that case too. Okay, that's how it works. You just don't start quoting something. I don't know which case you're talking about. Two, he testified that Mr. Carter started walking away from the vehicle, and then his partner initially approached him. That is, from my understanding, not in dispute. The partner is the one that had the conversation with him. That is not in dispute. He just overheard what your client said in relationship to responding to his partner. So there's nothing to refresh at this point.
I can move on now.
Thank you.
So Mr. Carter walks away from his vehicle, you see that, correct?
Yes. I do, I recall him approaching my partner, yes.
So now let's focus on the area and where Mr. Carter is when he's taken into custody, okay? Okay?
Like I said, I wasn't the one that took him into custody. So I can't testify to anything regarding taking him to custody, putting cuffs on him or anything like that. I don't know anything about that. I was doing my job as my partner's partner. So my job is to assist. So when the defendant had stated that there was a gun in the car and somebody had a CPL, my job was to make contact with the other occupants in the vehicle.
Okay, so I'm gonna stop you right there because my question wasn't not whether or not you took Mr. Carter into custody, was where he was at when you could see him. And according to your body cam, Your Honor, this was going to be.
Okay, both, you don't testify, and you didn't ask questions. You said something about, we're gonna talk about this.
And I was just.
I'm talking. And then you started talking again, so if you have a question, go to the question.
As Mr. Carter is walking towards your partner, he's walking away from his vehicle, correct?
Yeah, who stated that?
So Mr. Carter is no longer within arm's reach of the driver's side car door, correct?
This is true.
He's not anywhere near the ignition of the car, correct?
This is true.
He's at the butt end of the vehicle, the rear end of the vehicle, correct?
This is true.
And like you testified to, your partner put cuffs on Mr. Carter, correct?
Yes.
Now let's talk about the exigent circumstances as written in your police report that you had to search the vehicle.
Now, I apologize, ma'am. I didn't write that police report.
I'm sorry, that was just a foundational. I'm just trying to pinpoint you to the time I'm trying to talk
But
to
you
you.
said your police report. Go to your question. Not his report.
Did you write a report after this incident?
I did not.
Why not?
My partner wrote the report. He states the actions in that police report.
And if your partner writes a report, you don't write a report?
Not usually.
And that's Michigan State Police practice and procedure and protocol, is what you're saying?
That's just how me and my partner do it, yes.
According to you, Mr. Carter voluntarily told you that there was a firearm in the vehicle.
Can you rephrase?
According to you, Mr. Carter voluntarily he states out loud that he has a firearm in the vehicle.
Yes.
But that's not
Okay,
true.
well, that's not exactly what the testimony was. What the testimony was, that Mr. Carter said that there is a firearm in the vehicle. Not that he has one, but that there is one in the vehicle. Which one is it?
Sir, he did state he has a firearm in the vehicle. Do I know the questions that were asked prior to that for him to state that? That's why I said I
He
can't
said that
testify.
he has it or that there is?
There is.
There is, because there's a difference. Right?
And according to you, Mr. Carter just offers that information up. Correct?
Like I stated before, ma'am, I don't know what questions were asked to lead to that answer. I have no idea. I'm not the person who made contact with him. I heard that there was a firearm in the vehicle
If I may.
and that somebody has a CPO.
You gotta let them finish the question, if you may what? You gotta, if you ask them a question, you gotta allow them to finish his answer.
I understand, and what I would like to do at this point in time is to show him his body worn camera since he's implying that he does not recall at
He's
least
not implying he
something.
doesn't recall anything. He said he
Okay.
didn't hear what was asked, he heard what your client said.
And that's my question, is that I'm not asking what was asked, I'm not asking the questions that were asked, I'm asking what he heard. And he's saying that in his response to my question is that he didn't hear the questions leading up to the answer, which is not a response to my question. So my question to you is this.
Okay, wait, no, you don't start arguing and tell me about something and then go back to him. No, we finished what we're gonna do. That he also gave the answer to your question. Your question was, what did you hear? And he said he heard that your client said that there was a gun in the car. Okay, that's what he heard. He said he didn't hear the question, whatever his partner said, that led up to your client saying that, but he heard your client say that. And based on your client saying that, he did certain actions, i.e. he went to the car to see if there was another person in there. You know, that had a CPL, didn't find anyone. All right, so please take it from there. Go ahead. Yeah.
My question is not about what you heard your partner ask. My question to you is that you heard Mr. Carter state that there is a firearm in the vehicle.
Yes, I did hear them state that.
And as Mr. Carter is taken into custody, you're walking toward Mr. Carter's car, correct?
As far as I remember, yes.
And at that point in time, Mr. Carter doesn't even know why he's being detained. Or at least you told him that he was being stopped for traffic offenses, correct?
I didn't tell him anything that I recall. I know my partner made contact with him.
Your testimony on direct examination was that he was pulled over for a traffic stop because you noticed that he was not wearing a seatbelt. So that is still your testimony, correct?
Yes.
So Mr. Carter, to your knowledge, was pulled over due to not wearing a seatbelt, correct?
Yes.
And it's your practice to go and look for evidence inside of a car for a person who's not wearing a seatbelt?
When somebody says that there's a gun in the vehicle and they don't have a CPL, and then that their girlfriend has a CPL and nobody else is in the vehicle, yes, I would say there's probable cause to enter the vehicle to retrieve the firearm.
Well, you just admitted to the fact that you had already started walking towards Mr. Carter's car before he even made that statement.
That's normal practice.
Normal practice
Yes.
to go look for evidence of a traffic-related offense inside of a vehicle?
It's also normal practice for us to make contact with other occupants in the vehicle. It's more of an officer safety issue, because if we're both dealing with him, there could be somebody else in the vehicle that could try and ambush us.
But you didn't walk over to the passenger side door of the car, did you?
Not that I recall.
You didn't walk over to the driver's side back door car, to the door to the car, did you? You didn't walk over to the.
Now without watching body cam, ma'am, you're asking me questions, you're not giving me an opportunity to answer them. Not without seeing my body cam.
You wanna answer your questions, you have to let them answer. You're going from one question to the next question to the next question without giving him an opportunity to answer. So please, let him answer your questions.
His last answer to my question was that if he had enough.
I don't ask you what he said. I'm not asking you to respond. I'm asking you to allow the witness to answer the questions that you ask him. Now go to your next question or to a question.
You did not go and check the back passenger side door to see if there was other occupants in the car, correct?
Ma'am, I don't recall everything that I checked, but I know that I was able to confirm that there was no other occupants in the vehicle. Especially someone that would have been closest to the gun, which was in the front passenger door.
But you testified to the fact that you had watched Mr. Carter walk out of the car, did you not?
We've already gone through this. You've asked him that like 3 times. I don't need to hear it anymore.
And Your Honor, at this point in time, understanding the court's ruling, I would like to, the trooper has offered that he does not remember and that if he had the opportunity to review his body cam, that his memory would be refreshed. And if the court would
He
allow.
has not. He's answered all your questions. Go on to your next question, please.
You had to remind your partner to read Mr. Carter his Miranda rights, correct?
Not that I recall. I don't remember. Like you said, I can watch my video if that's what you would like. But I don't recall. Like I stated to you previously, I wasn't the person who made the initial contact with him. I was the passenger. I was the passenger in the patrol vehicle, and I have certain obligations as a passenger in the patrol vehicle.
At this point in time, I would like to make the motion again to offer to allow the trooper to refresh his memory by looking at his body on camera.
As to whether or not he had to remind his client, not his client, his partner to give a Miranda warning? That's what you want to refresh his memory on?
Your Honor, for the record.
That's the question. That's a yes or no answer.
Yes.
No, it's not relevant.
Miranda.
When he Mirandized them, it was after everything else happened already. So there was a certain sequence of events here. The vehicle pulled in, they went to stop it. Your client got out of the car. I assume once he saw the lights and stuff, he walked straight towards the officer, who is this officer's, trooper's partner. They had a conversation. This trooper then started walking towards the other vehicle, not towards his vehicle. When I say his, I mean Mr. Carter's vehicle. During that process, his partner is talking to your client. And your client makes a statement that he hears about a gun. So now he goes to look at the girlfriend and a CPL. That's what we got. He goes to look, there's no girlfriend, no CPL. Now he's gonna search the vehicle. Searches the vehicle, finds a gun. I assume once he said that there was a gun in the car and there was no one else in there, then your client got arrested. Now, when he got arrested, that's when he got his Miranda rights. Is that true? Are you gonna? No, if you shake your head one more time, I'll put you in the back. You understand? You have the right to sit there and listen and watch. You don't have the right to respond. You understand that? Do you understand, Mr. Carter? Thank you. So, what's your request at this point?
Your Honor, it's the defense's understanding of the sequence of events of that night, that Mr. Carter was not read his Miranda rights after he was detained into custody, before he was asked questions which elicited an incriminating response, and that is, and if the people are only pro-offering this one witness and not the trooper who actually detained.
You have the right to call any witness you want.
Understood. Understood, Your Honor. No further questions at this time.
No further questions for this witness.
Thank you. Any other witness?
The people called no more witnesses.
That's
Defense calls Trooper Smith.
Trooper Smith here. Did you subpoena Trooper Smith?
I have not seen it to person.
We'll see if he's here.
Person?
Dane.
Scott?
Smith.
Step up here, please. Raise your right hand. Where our firm, the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, pull the door towards you. You have a seat, please. And proceed.
Good morning, Trooper Dan Smith. Where are you employed?
Michigan State Police, Metro South Coast,
How long have you been employed with the Michigan State Police?
approximately 5 years.
And what position do you have in the Michigan State Police?
Trooper.
And I want to take your attention back to the date of May 30th, 2023. Do you remember that date?
I do.
Were you working that day?
I was
What were your duties that night?
patrol as a trooper.
Were you alone?
I was not.
And did anything happen that night that brings you here today?
Yes. I arrested DeWine Carter.
Let's break that up. Where did you initially see Mr. Carter?
His car was at a stop sign along Davison Road.
And what, if anything, did you see that brought your attention to Mr. Carter in the car that night?
I believe we observed that he wasn't wearing a seatbelt. He had a white t-shirt on.
So you're saying you could see that he was not wearing a seatbelt?
Correct.
Was there anything else that you observed?
After we followed the vehicle into the gas station, we observed there was no registration plate on the vehicle.
And after realizing that he was not wearing, and you would consider not wearing a seatbelt and no registration plate as traffic civil infractions, correct?
Correct.
Now, after realizing that Mr. Carter may have been, or allegedly is not wearing a seatbelt or has registration on his plates, what do you do next?
We enacted a traffic stop.
And did you complete a traffic stop?
Yes.
And what happened when you did, when you conducted the traffic stop?
Mr. Carter exited the vehicle.
And when Mr. Carter exited the vehicle, was he walking away from his car and towards you?
Yeah, towards us, kind of. He was at a gas pump, so his only way out of the vehicle was to walk past the pump back towards us, towards the rear of the vehicle.
And do you get custody in event or detain Mr. Carter?
Yes.
And what happens then?
Mr. Carter states that there's a firearm in the vehicle. He does not provide any form of identification or driver's license, and he's placed into custody.
So let's break that up a bit. You said you had a partner that night, correct?
Correct.
Where was he? Was he also helping you take Mr. Carter into custody?
No, and not in the sense that I was the one that placed Mr. Carter into handcuffs.
And where was he parking? Could you see him?
I wouldn't be able to tell you from memory exactly where my partner was standing. I believe he may have been around the back side of the patrol car. Our patrol car was at an odd angle during the traffic stop.
Well, do you remember telling your partner? Do you mind double checking around the driver's seat that there's nothing in the car, right?
I believe after Mr. Carter identified that there was a firearm in the vehicle and failed to identify him being a CPL holder, my partner went and secured the firearm.
So it's your testimony today that Mr. Carter had made that statement before you asked your partner to go and search the vehicle?
You're gonna have to rephrase that.
What you're testifying to today is that the reason that your partner went to go over and search the vehicle was after Mr. Carter had said that there was a firearm in the vehicle?
Yes.
Your Honor, may I play his body cam on camera in order to show the impeachment of the sequence of events as he has testified to right now?
Sure.
Court's involved. Your Honor, how would you like for me to sign into this?
Put it on Zoom. Sign in.
Yeah. Yeah.
Am I going to shoot?
You have to turn your sound off. Sound through the system here. Turn it off or turn it all the way down, otherwise we're gonna have feedback.
Okay, I muted it. Should that work?
Yeah, and just play it through. It's already on share, so you can, turn it on and see if the, officer can, authenticate.
Marking this as defense exhibit. Your Honor, doesn't matter if I use letters or numbers.
Just do it, A.
A, defense exhibit A for purposes of identification. Opposing counsel has sent over this video in discovery.
I don't need you to testify. What I need you to do is authenticate the video.
Mr. Trooper Dan Smith, I'm going to play a clip, a second of this video, and I want you just to let me know if this is your body cam, you remember from the minute, okay? For the record, beginning the video at 0.02. Pausing at 0.06. Trooper, does this look like your body worn camera?
It does.
Beginning the video at 0.32. And just To remind you, my questioning was regarding whether or not Mr. Carter had made that statement before.
Okay, you're testifying. I don't need you to testify. You want to show the video as impeachment, show the video as impeachment, and then I can see it.
Okay.
And then once you finish, then if you have some more questions, then we go through, but I'm not gonna have you testify.
Understood you. Plain or video? There's no audio.
Go, take it back, don't take it, put it off, don't mute it, just turn your sound on your computer down, and we should have the sound here.
My partner, you mind just double checking around the driver's seat? Nothing in the car, right? Nothing in there tonight?
My girl, my baby mama, my baby mother, sister is in there. It's in
Were you able to hear?
Yep. Yes, ma'am.
You heard yourself ask whether. You heard yourself asking whether there was something in the car?
Yes.
And Mr. Carter responding to that?
Yes.
At some point in time, after Mr. Carter is taken into custody, what happens after that?
What do you mean? I guess I need more specifics. There's a lot that happened after Mr. Carter was taken into custody.
Where did you place Mr. Carter while he was being detained?
He's placed in my patrol car, the front seat, front passenger seat.
Were you in the car with him at points in time?
Yes,
Were you speaking with him?
I was.
Were you questioning him?
Yes,
Did you read his Miranda rights?
I did.
Was that before or after you began to question him regarding the pistol, the CPO, or any other of those questions that you testified to?
I'm not sure what our conversation consisted of prior to Mirandizing him. I know that I Mirandized him and then re-questioned him on the subject.
Do you remember after reading his Miranda rights, you said that you don't have much to say right now because you already got everything you needed?
If it's recorded, yes, I said that. I don't remember it specifically.
Nothing further, Your Honor.
No further questions.
Yes, sir. Any further witnesses on the behalf of the defense?
No further witnesses, Your Honor.
No further witnesses. The people motion to bound over on all counts. Officer Arkin testified that the defendant was not wearing a seatbelt. There was no registration plate. The Officer Smith was the driver of the police vehicle. They pulled over the defendant. When pulling over the defendant, there was a conversation that was overheard by Officer Arkin where the defendant said that there was a firearm in the vehicle. The defendant, per the ROA that was submitted to the court, is not eligible to carry the firearm. The people motion to bound over on all counts.
Your Honor, defense asked that this court not bind over Mr. Carter on the alleged, on the following counts due to the prosecution's inability of proving probable cause that was necessary to search Mr. Carter during his time in incident. Your Honor heard testimony from both troopers that have testified today regarding the probable cause that warranted the stop, which was traffic-related offenses. which traffic related offenses, there's no evidence inside of a car that would necessitate a search that would show that there's evidence of a crime related to a traffic offense. So it's the defense's position that there was no probable cause or exigency, I apologize, that necessitated a search. And we ask that this court not bind over on the alleged counts.
Rebuttal. Nothing further from the people.
For having heard the testimony and argument, I follow the first heard from State Trooper Arkin Eli, Michigan State Police, at 5/30/23 in the area of Davis County, Illinois, City of Detroit. He observed the vehicle, the driver having no seatbelt. Identified the driver as the defendant. When we pulled into a gas station, defendant pulled in afterwards and went to do a traffic stop. They also noticed that there was no license plate on the vehicle. Activated the lights, defendant got out of his vehicle. I guess just from the position of the vehicle, he had to walk towards the trooper's car in order to go into the gas station, wherever he was going to do. And Officer Arkin testified that his partner approached the defendant, and that he heard the defendant make a statement regarding a gun being in the vehicle that it either belonged to his girlfriend or his girlfriend had a CPL. He went to look in the vehicle, see if there was anyone else in there. The defendant was the only occupant of the vehicle. The search and found a loaded firearm. Also heard from Trooper Dan Smith, Michigan State Police, same date, same incident. Actually, the officer that arrested the defendant, he said he initially saw the car at a stop sign. The driver had no seatbelt. And also noticed there was no registration plate on the vehicle. Made traffic stops, and the exit of the vehicle, walked towards them. He also stated the defendant did state that there was a firearm in the vehicle, but that was in response to his question regarding any firearm, etc., in the vehicle. You know, at the point that he stopped the defendant and asked him, it was a traffic stop. He had a right, it was probable cause to stop and make contact with the defendant. He asked him about the firearm. He wasn't under arrest. He wasn't required to Mirandize him at that point. In fact, your client didn't have to answer. He didn't have to say a word. He could have just kept his mouth shut. And the other officer would have just walked over to the vehicle, looked inside from the outside like they always do. And that would have been the end of it. But your client is the one that told him there was a gun in the car. You know, the client has certain rights, but rights are, they have to be exercised. If you don't exercise your rights, hell. And because of that, he's the one that gave them the right to look into that vehicle and search it by making a statement saying that there was in fact a gun in the vehicle. He didn't produce a CPL. He didn't even produce a driver's license. So at this point, the court finds that the felonies enumerated in the complaining warrant did in fact occur in the city of Detroit. Probable cause of this charges will be bound over to Wayne County Circuit Court Criminal Division for arraignment on the information. Which will be July 6th at 9 o'clock.
Start this week. Thank you, Judge.
Thank you.
You have a hearing within a week, so, I mean, Oakland County has to really, you know. We have.
Oh.
You would have to file a writ, signed by a judge there, and, you know, brought back over there. Depending on when this next hearing is. I don't know what he has over there. Have something in progress, or is it just a violation or whatever?
So there's a potential that they might not even let him stay here. Okay, I'll let him know. Do you mind if I go back to the speaker?
Mr. Ricketts. Yeah.
You ready, Mr. Reagan?
I'm ready.
Yes, sir.
Any more, hands?
Any more of what?
Legal hands?
Yeah.
Well, I'll add a couple pages.
Should be a lot upstairs.
I can't remember, bring them down. Bring them down.
Okay. Very good.
Oh, thank you.
So we do have Mr. Escalation.
Oh, okay.
Sir, you're going to step up here and go to your attorney, please.
Is he on, right,
Yeah, I think
prosecutor on
Jan's
Ali? Parties ready on Joshua Ali? Calling case number 2157190, the people of the state of Michigan versus Joshua Ali. Defendant number 1 is charged with count 1, home invasion first degree. Count 2, assault or assault and battery. Count 3, assault or assault and battery. This matter is scheduled for exam.
Good morning, Judge Alex Ryan, on behalf of the people, P number P86590.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defense Services by Ken Riggin, P82125. On behalf of Mr. Joshua Ali, who stands with me to my right. Mr. Ali, can you state your name for the record, please?
The people are unable to proceed as the necessary witnesses have failed to appear.
Your Honor, in light of that representation, I'm going to state this is Dr.
Yes, Mr. Hoffman?
Thank you.
Thank you, Judge.
Oh. We already got one.
You doing that, Judge?
All right, how you doing?
Yes. Parties ready on Melanie Van Largen,
We are ready.
calling case number 1260918. The people of the state of Michigan versus Melanie Van Largen. Defendant is charged with count 1, operating license suspended, revoked, denied, causing serious injury. Habitual offender, third notice. This matter is scheduled for exam.
Good morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, P number 85828. Hearing on behalf of Melody Van Largen, who's present in the courtroom today. Ms. Van Largen, please state your name for the record.
Melody Van Largen.
Thank you. All right, you ready to proceed?
Your Honor, the people are not ready to proceed. This is a 2012 case. We have been unable to locate the alleged victim. And in addition to that, the officers involved in this case.
I need to dismiss.
No, it's just moved off.
Thank you, Your Honor.
Thank you.
Have a good day.
Ms. Brush.
Sounds like we got a minute. Am I right? I think we have a minute, so I'm gonna go run up there. Everything will see.
Oh, okay.
I think it's a couple minutes.
Another side.
Ready, Kim? Calling case number 2256268, the people of the state of Michigan versus Kozak Esco. Defendant is charged with count 1. Police officer assaulting, resisting, obstructing, habitual offender, fourth notice. This matter is scheduled for exam.
Good morning, Judge Alex Running on behalf of the people, P number P86590.
Good afternoon, good morning, Your Honor. Stephanie Carson on behalf of Mr. Esco, P57096.
Mr. Esco, can you state your name for the record, please? Thank you, sir. All right, we ready to proceed?
We are, Judge, and the people call Sheriff.
Excuse me, just one, Your Honor, just for the record, can we have a mutual order sequestration? I don't have any witnesses, prosecutor, but if there's anyone in the room, I'd ask the court to advise.
All right. Anyone testifying today at trial or any time in the future, must see the courtroom, Zoom, or YouTube, or be denied their future testimony.
Thank you.
Thank you, Judge. The people call Sheriff Timothy Taylor. Yep.
You swear the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
All right, put the door towards you.
Good morning. Could you please state your name for the record? Oh,
Corporal T. Taylor.
and
I'm sorry, Corporal what?
T. Taylor.
T. Taylor.
what is your job?
I'm a Wayne County Sheriff Deputy.
And how long have you been a deputy for?
Between 7 years since this October.
And were you working as a deputy on 12/06/2021?
Excuse me, Your Honor. Excuse me, if the deputy is referring to something, if he has something in his hand, I ask that he put it down. Thank you.
Were you working on the date of 12/06/2021?
12/06.
12/06/2021.
After
December 6th.
December 6th, I'm not sure about work, December 6th of 12/21.
Do you work at the location of 570 Clinton Street, Jail Division 1, Detroit?
I used to work there. As referred back to my paperwork for the date in question.
Referred to as paperwork, so.
Maybe refresh your memory.
Yes, on my paperwork.
We'll get the paperwork to refresh your memory, and then place it back down.
On December 6th, I'm not sure if my paperwork for that incident didn't occur on December 6th.
Is your first name
Yeah.
Timothy or is it T?
Timothy.
Okay, thank you.
Mr. Taylor, can you move back just a little bit?
Yeah, because that's.
Was the date 10/05/2021?
Correct.
And on that date, were you working at 570 Clinton Street, Jail Division 1, Detroit?
Correct.
And that's in Detroit County of Wayne?
Yes.
And On that date, what are some of the duties you do on that, at that location?
On that date, I was working with the COVID team on going around testing inmates for COVID, but I also assist any officer in the need assistance.
And when going around and assisting other officers, what happened?
On that particular date, an officer asked me to assist them with serving lunch.
And when you were assisting with serving lunch, what happened next?
Well, I was passing out lunch on the 11th floor. They were locked down due to COVID, so I had to go in on the ward, pass out the lunch trays individually.
And when you're passing out the lunch trays individually, what happened next?
Well, went to Mr. Esco's cell door. I opened his door to hand him his tray, and he refused to let me close the door.
Do you see the defendant who you had that interaction with in court today?
Yes,
Can you point to a piece of clothing that they're wearing?
the green county shirt.
Please let the record reflect that the witnesses identified the defendant. Explain to me more of this conversation you had with the defendant.
Well, on that day, after I served him this tray, he blocked the door with his foot. I was telling him the consequences if he doesn't step back in the cell. And after a few minutes, he complied with no problem. And I closed the door.
After you closed the door, what happened next?
I checked the door to make sure it was secure and locked. And at that time, he threw a liquid substance in my face and told me I had to refer to my notes, my paperwork, the exact words he said.
Yep. Judge May, the witness, refresh the recollection.
Yeah.
Okay, as I shut the door and was checking the security to make sure it was locked, he called me, the bitch, that piss was for her, so fuck all y'all. I will fuck all y'all up.
Was it, so what was the substance that he threw on you? Do you know?
He said it was piss.
And when you were working that day, what were you wearing?
I was in my uniform with, at that time I wasn't wearing glasses. I just had a face mask on.
What kind, what uniform?
Oh, I was in my Wayne County brown fatigues with my name, my sheriff emblem.
No further questions.
Good morning,
Good morning.
Deputy. Now, had you had any prior contact with my client?
Yes,
All right, so were you aware of mental health issues with my client?
no,
Were you aware of any disruptive behavior by my client
no,
prior to this? Were you aware of my client being on suicide watch?
no.
Why were you asked to assist specifically with my client or just with serving lunch?
Was serving lunch.
And while my client said it was urine, he actually threw a juice carton at you, correct?
He
threw okay, whatever liquid was in the juice carton, correct?
Correct.
All right, and while you were, there was an assault, you had no injuries, correct?
I went to the doctor said I was fine.
Okay, thank you. Did the doctor identify the substance as urine?
No, you did not.
So basically, the belief that it's urine is based on my client's statement alone, correct?
Yes,
And my client was actually written, if you know, are you aware that my client was written from the prison And that's why he was at Wayne County Jail, if you're aware, are you aware?
No,
of that?
I wasn't aware.
No further questions, Your Honor.
No further questions. Thank you, Mr. Dunn.
Oh, excuse me, Your Honor, I apologize. If I may ask just one brief question. This happened a little while ago. So based on your report, didn't you actually say that you closed the door and then you went to actually check to make sure it was locked?
Yes, that's procedure.
Right. So his foot wasn't in the way then, correct? When you went to check for the door, his foot wasn't in the door, right?
No, you removed it.
Okay, thank you.
Nothing further. Thank you, Mr. Dunn.
Sorry, Councilman. Okay, I didn't- okay, great. Yeah, this has no words.
All right.
Prosecution has no further witness. We motion to bound over on count one. Sheriff Timothy Taylor was working in his capacity as a sheriff, and as he testified in the sheriff uniform. The defendant in his statement saying that it was piss, the substance that was thrown onto the sheriff. The people motion to bound over on count one.
Yeah, well, yes, I don't think the issue is that, I think no matter what the substance was, it's a question of fact as to the assault. I maintain there's no evidence that it's urine, but I don't think that's necessary for the charge.
Right. All right, court having heard the testimony and argument, I follows. Heard from Corporal Timothy Taylor, Wayne County Sheriff Department, at 121021 at 570 Clinton Street. He was assisting and serving lunch on the 11th floor. He went to hand the defendant his lunch. He identified the defendant. First, he refused to let him shut the door. They complied. He went back to check the door and the defendant threw a liquid substance in his face. Although initially he said it was urine, the doctor said it wasn't, and the sheriff said it wasn't. More likely the juice that was in the juice container. But it, it was irrelevant in terms of what it was, the fact that it was done. Or find that the felony enumerated and complaining warrant did in fact occur in the city of Detroit, which caused this exists to charge this defendant. We found over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be July 6th at 9 o'clock.
Thank you, Judge.
Yeah, and I don't know if this is something the court can handle. My client is actually on writ from prison. So what he would ask is if he could go back, have the writ canceled and appear via Zoom for the further hearing.
Well, the arraignment is on Zoom anyway, so they're probably going to send it back.
Great, so you.
I don't have any control over that.
Okay.
More that's normally what they do. And then you'll proceed by Zoom or from there for the arraignment, final conference, anything like that, motions, if there are any. And only reason you would be brought back if it goes to trial. All right?
Thank you. All right, take care. Everybody have a good weekend. You too.
All right, two. Barbecue?
Yes, you coming back?
Tell me when.
Okay, all right, guys. I'm sugar-free, so it's soft on the other side.
That's fine.
Okay.
That's fine with me.
Oh, here.
You might have to judge. You
Oh,
might
that's
not-
for,
They might not be all right.
Hi, that was the fingerprint.
Oh.
I don't know, you know what, I was trying to.
Oh,
You walk away.
That's everybody.
Okay.
You're like 2 years old, right?
Bring this done, isn't it?
Yes.
Morning, Judge.
Good morning, how you doing?
Good, how are you?
Hanging in there.
Okay. Somebody gets something.
Oh, it might have been,
She just walked out. I'll get to the front.
Arson.
Might be a person, too. That was gonna be missing that. Okay.
Parties ready on Ernest Montgomery. Calling case number 2357129, the people of the state of Michigan versus Ernest Montgomery. Defendant is charged with count 1, larceny, $20,000 or more. Count 2, stolen property, receiving and concealing, $20,000 or more. Count 3, scrap metal, habitual offender, or notice. This matter is scheduled for exam.
Nope, this is Dan's case, he just walked outside.
Oh.
I want to go get it. Check.
Well, just tell him.
This one, can I get the number? This one? No.
58-696.
Oh, I'm sorry, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Morning, Your Honor. Susan Dunn, 258-696, on behalf of Ernest Montgomery, who stands to my right.
Can you take the name for the record, please?
Good morning, Your Honor. And I thank you for, I ain't been in court in a long time. I'm a little nervous this morning, but I want to thank you and your court this morning. I'm here.
Tell the judge your name.
Oh, my name is Ernest Andrew Montgomery for the record. I'm sorry, Your Honor.
All right.
I apologize.
All right. All right, you ready to proceed?
The people are ready to proceed, Your Honor. The people will call Brandon Yarsicki to the stand.
Spell that last name?
Yes, Your Honor, it is Yarsicke.
K-E.
That's correct.
First name? T-R-A. Y-A-R-S-I-C-K-E. No C. Y-A-R-S-I-K-E. Perfect. Okay. You're not an officer.
No.
So how many questions? Right there. Raise your hand. You swear or affirm so the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, you pull the door towards it. Now, sleep, please. All right, Mr. Yarsicki, you're gonna be asked a series of questions. First, by the prosecutor. And the defense attorney will probably ask you some questions.
Okay.
And I may or may not ask you questions. Okay. You have to answer all your questions out loud verbally using words. Just mean shake your head or say, it's a yes, no, whatever the answer is. Understood. Also, I need you to listen to the question and just answer the question and stop. So if it's a yes or no type question, it's a yes or no. If they need additional information, they'll just ask you another question, all right? We all have a tendency when we want to tell a story or tell something that's happened, we want to get the whole thing out. Say this happened and this happened and this happened and this happened, go like, to get it all out. Well, if you do that, I'm gonna miss something. If I miss something, I'm not gonna get the right decision. Okay. I know nothing about this case. The only thing I know about this case is what's in its name, what it's charged with. I know your name. I get all my information for what happened in court. That's why I go one question, one answer at a time. That way I can understand it. Okay?
Understood.
All right, thank you.
Thank you, Your Honor. Mr. Yarsicki, could you please restate your name, your full name for the record?
Brandon Yarsyk.
Yarsyk. My apologies. Brandon, where are you currently employed?
Socorro Metals.
Okay. So I'm going to take you back to August 16th of 2021. Were you employed at Socorro Metals on that date?
Yes.
So it's Socorro, let me take you to the address of 12850 Mount Elliott Street. What's located at that address?
Scrapyard.
Okay, and which scrapyard specifically?
Socorro Metals.
And is that in City of Detroit, County of Wayne?
Yes.
Okay. So, and I apologize, were you employed at Socorro Metals on August 16th of 2021?
Yes.
Were you working that day?
Yes.
Okay. So on August 16th of 2021, did you encounter a Mr. Ernest Montgomery at that time?
No. One, you leave. You're suggesting fact, not an evidence.
Understood, Your Honor. I'll rephrase. Brandon, did you on August 16th see anyone at your place of business that is currently in this courtroom?
Yes.
Okay. Could you please point to that individual that you saw and identify them by an article of clothing they are wearing?
The man in the red suit.
And Your Honor, made the record reflect the identified defendant in this case. And prior to August 16th of 2021, did you know the gentleman that you have identified as the defendant in this case?
Yes.
Okay. Do you know this gentleman's name?
Yes.
Okay. What is this gentleman's name?
Ernest Montgomery.
What did Ernest Montgomery come in to do on August 16th of 2021?
Sell scrap metal.
Okay. And did you handle that transaction?
I did.
Okay. Were you able to personally observe the items he was selling on that day?
Yes.
And what items was he selling on that day?
Various metals. I don't remember everything that was on his ticket.
Okay, so was there anything unusual that he was selling on that day? Things that you don't typically see an individual selling?
A scrap metal, stainless steel hopper barrel, I guess you would call it.
Okay. So you described a stainless steel metal barrel. Is this something that?
Objection, I think he said it was a hopper barrel, Judge.
Correct.
Misstating the.
That's fair. I can rephrase that for the record. Mr. Ernest Montgomery came in that day with a stainless steel hopper barrel. Had he ever brought in an item matching that description previously?
Yes.
Okay. All right. How many times had he previously brought in an item matching that description to your recollection?
3 or 4.
Okay, and Within what time frame had he brought these in? Was this over the course of 10 years? Was this?
Suggesting facts, just ask the question, let the witness give the answer. You can't put the answer in the question.
My apologies, Your Honor. You indicated that he had sold these hopper barrels previously. Over what time frame had he sold additional hopper barrels?
A month or two.
Okay. In your line of work, is it typical for these items to come into your scrapyard?
Oh, what? Other relevant.
Your Honor, I've offered this because these are fairly unique items that aren't typically brought to the scrapyard or found generally.
What difference does it make? So if you brought in a gold bar and said, I want to trade this in, you know, that's an item that's not typically brought in. What does that have to do with the charges that's going on today?
Yeah, absolutely, Your Honor. So my next witness, Thomas Molina, will testify that these are special ordered barrels.
Well, we'll deal with that when your next witness come on. I only need to know what he saw, what he did, in relationship to this.
Nothing further than this witness at this time, Your Honor.
Sir, how long have you worked at Socorro?
17 years.
Yeah, and you saw Mr. Montgomery here only in recent months from the date of this alleged offense, correct?
I had seen him prior. He had been coming off and on for several years.
Okay. You said that Socorro is a scrapyard, correct?
Correct.
So these hopper barrels, they weren't new, were they?
They didn't appear to be new, no.
I saw a video and it appeared to me that they didn't have doors on them. Is that what you recollect? If you recall.
I don't recall.
Okay.
I don't.
But did they appear to be, they did appear to be used to you, not brand new?
Correct.
Nothing further.
And nothing further for this witness, Your Honor. And the people would call Thomas Molito to the stand next.
Thomas? M-A-L-I-T, or M-E-L-I-T-A? That's correct. Perfect. Step through here, judge will swear you in.
Morning, Judge. Good morning. You raise your hand. Do you swear or affirm to the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, please pull the board for you, please. See? Is it Lolita? It is. Okay, Mr. Lolita, you're gonna be asked a series of questions. First by the prosecutor, then by the defense attorney, and I may or may not answer questions. All right. If you have to answer all your questions out loud, verbally using words, just can't shake your head and say, everything's being transcribed. All right? Yes. Also, when you ask the question, I need you to answer that question and stop. So if it's a yes or no type question, just say yes or no. And stop. Okay. If they need additional information, they'll just ask you another question. All right? Also, we all have a tendency when we're telling a story or event, we tend to ramble. You want to get it all out, so we say this happened and this happened and this happened. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision. Okay? That's why we proceed by one question, one answer, so I can understand what happened. I know nothing about this case, other than what I hear in the court. Okay? Yes, sir. All right, thank you. May proceed.
Morning, Mr. Molina.
Morning,
And could you please restate your full name for the record?
Thomas Molina.
Thank you, Thomas. So I want to take you back to August 17th of 2021. Now, were you at the address 1750 Filer Street?
If I could correct that, 17450.
17450, were you at that address?
I was.
And is that in the city of Detroit, county of Wayne?
That's correct.
And what is at that address?
We are a company that.
Now you say we, let me take it back. Could you just tell me what is at that?
Metal finishing business.
Okay, metal finishing business. And what is your relation to that metal finishing business?
One of the owners.
So on August 17th of 2021, did you uncover anything at that address?
We did.
Okay. And what was it you discovered at that address?
I want to make sure we understand the question and how to answer it. You can't say what we did.
I did.
You can't say what anybody else did.
Yep.
Or what anybody else told you. You can only say what you actually did yourself, you saw yourself. Okay?
I got you. Thank you.
Thank you.
Yes, I did.
Okay. And what did you discover at that address on that day?
We were missing very large stainless steel barrels that we utilized on a particular piece of equipment.
Okay. So can you describe these barrels to me? What are they made of?
They're made of stainless steel. They're used to process fasteners. We probably process upwards to.
Okay, let me stop you right there. So you described them as being made of stainless steel. Is this something that is ready-made or special ordered by yourself and your firm?
Specially made for the line that it's utilized on.
So after discovering that these barrels were missing, what steps did you take to investigate?
I, along with others, made attempts to understand how these barrels could be missed.
Okay, so let me interject briefly here. Did anyone have permission to take these barrels away from this location?
No.
Okay. Did anyone have access that was employed by your business at the time?
They did.
Okay. So you conduct some investigative steps to determine where these barrels went.
Correct.
Do you ever locate these barrels?
Yes.
And where is it that you locate these barrels?
At the recycling yard called Sequoia Metals.
Your Honor, I would object to this. I don't know if he walked over to the scrapyard and found them or how he got them. I don't think there's been any foundation laid.
Hasn't been any foundation.
Agreed. I can lay a foundation, Your Honor.
Please don't lead.
I'm sorry.
Please don't lead.
Understood. So after discovering these barrels are missing, where did you begin your investigation?
The very first thing we looked at, very first thing I did, we looked at what video we had to understand access to that particular area.
Okay.
And recognizing how large these barrels are, that it would require a significant effort to roll them out.
Okay.
So we had no video from our access point, which only left the very back of the building that
So you have, there's no video showing who took these barrels, is that correct?
That's correct.
So after determining there was no video of this incident, of whatever happened to these barrels, what did you do next?
We decided to visit.
Please.
I decided to visit, in fact, it was me, scrap yards, because that's what where they usually end up. The things end up at recycle or scrapyard. So I went to McNichols first, didn't see anything, spoke to individuals, and then I went to Sequoia, and that's where I located.
So you went there and you said you located those barrels there. With whom did you speak?
Well, you haven't said that.
I'm sorry, I wasn't misheard.
Scrapyard second, then he stopped his testimony at that point.
Were you able to locate those barrels at any of those scrap yards you visited?
At the Sequoia recycle scrapyard, I did. I pulled on in, saw the barrel. There was a couple gentlemen right there. And
well, let me stop you there. Did you speak with any of those gentlemen without telling me what they said?
I did.
Okay, so did they provide you with any paperwork as to how they acquired those?
They did.
Okay, those being those barrels. Just one moment, Your Honor. Permission to approach a witness, Your Honor. I'm going to provide him a copy of the receipts he received.
I'm not objecting, well, Judge, I think that hearsay, you know, the person to testify as to the receipts would have been the person who issued the receipts, not this guy that didn't issue them and really has no knowledge.
Your Honor, this would fall under the business records exemption to hearsay. These are records kept in the ordinary course of business.
Who's gonna testify that they're a business record? You have to lay a foundation for a business record. Who's gonna testify that they're a business record?
I could recall Brandon here. I could recall Brandon to the stand and have them verify.
Verify?
Authenticated.
If he dealt with them.
He did. His name is on the receipt.
I just renew my objection, Your Honor. You're right, this gentleman is not the custodian of the business records, and I had no prior notice.
Have you received things?
Oh, I did see the receipts, yes, they were in the discovery package.
Okay.
All right.
All right, you can show it to them. You can't authenticate them, so I'm not gonna enter them.
Okay. Go ahead and take a look at those. And when you're done, please turn them face down.
Pardon me?
When you're done with them, go ahead and turn them face down for me. I just handed you 4 receipts. Were those 4 receipts given to you at that scrapyard on August 17th?
I think they were given to me a day or two after that day.
Okay. So sometime within a day or two of August 17th, you were given those that I handed you.
I received these receipts along with video.
That's the question he asked me. We were given
Yes.
the receipt, yes. Thank you.
So let me take you back to the barrels that were on your property prior to you discovering they're missing on the 17th. Do your employees have access to those?
Yes.
Okay. Does anyone from the road have access to those?
Anyone from where?
From the road, would they be able to walk in and take them?
They have to go through the parking lot. So technically, yes, someone probably could, but we would be able to see that via our video.
Would any neighbors have access?
Yes.
Okay. So describe to me, do you see any of your neighbors here in court today?
Yes.
Okay. Could you please point to them and identify them by article of clothing if they're wearing?
Ernest Montgomery.
Your Honor, may record reflect that if I defend. You've identified Ernest Montgomery as a neighbor of yours. Relative to your property, in which direction is he your neighbor?
So he would be west of our main building and west of our maintenance shop, across from our main building, that is isolated between an alley, parking lot, and Brimson Street.
Okay. Is there any path from that property onto your own?
Onto where?
Onto your own property. Is there any path from Mr. Montgomery's property onto your own property?
Yes.
Okay. And have you had dealings with Mr. Montgomery prior to this, prior to the 17th of August?
What's the relevance?
The relevance is that he has done handyman work around the property, so he hasn't been in that property.
Yeah, I object, Your Honor. I think not only is it irrelevant, but it's prejudicial.
You did handyman work when?
In prior years.
Prior, year,
Yeah.
2 years, 5 years, 20 years, 30 years?
He did work relatively recently on that property as a handyman.
Okay, so what does that have to do with these charges?
He understood access and knew those barrels would have been present at that location.
I can object to
So
that.
would anybody that walked onto the property?
Well, Your Honor, just for the record, you can't say what my client knew.
Exactly.
Understood, Your Honor.
So go on to something else, please.
So, do you contact the police when you discover these barrels are missing? Let me rephrase. Do you contact the police the day you discover these barrels are missing?
Did not.
Okay. Do you contact the police in connection to these missing barrels at any point?
I did.
And when do you first contact the police regarding these missing barrels?
Oh, geez. It was maybe September-ish, 2022 is a lot.
September of 2022?
It's always a neck of the woods.
Okay. And when you contact the police, what do you tell the police regarding those barrels?
That they turned up missing. We reserved a concern about actually filing a complaint. And we had our own personal reasons why I did that. And
let me stop you there. You indicate there were some personal reasons as to why you did not file a complaint at that time.
That's correct.
I can object to the relevance, man.
To explain the time gap between going from August to September of the following year.
What's the statute of limitations on a larceny?
It's not within a year.
Okay. Not relevant.
So between contacting the police and discovering those barrels had disappeared from your property, did you have any contact with Mr. Ernest Montgomery?
Yes.
Okay. And what month did you contact Ernest Montgomery?
I actually had a discussion, I believe, may have even been the 17th.
17th
of August
of 2021,
asking him if he knew of anyone possibly taking the barrels, or did he hear anything that may have happened back there because he's in close proximity to the back of the building?
Okay, so let me stop you there. So when you asked him if he had any knowledge of anyone taking those barrels, what did he indicate to you?
He did not.
Okay.
And he changed the subject relatively quickly to talk about.
Object to this too. I mean, I understand that.
That's all right.
I'm sorry. I understand statements of, inculpatory statements of defendants are admissible, but not just chit chat. I don't think that falls under it.
I agree. So, see my question answered.
So after that initial contact that you had with Mr. Montgomery, and you indicated that was shortly after those barrels had disappeared in August of 2021, correct?
Correct.
Did you have any further contacts with him?
Yes, we.
Okay, so what further contacts did you have with him? Let's start with the month these contacts would have taken place.
Probably within a week. Had a conversation when he was pulling out of his driveway, at which time I asked him about it. He didn't have time for me. At that point, I told him I had video evidence.
Please. What's the objection? I'm sorry.
I'm sorry, Judge, what was it?
Did I hear an objection?
I mean, I just said that I renewed my objection. I mean, I think all these conversations with my client are hearsay unless they're inculpatory.
Right.
Understood, Your Honor. Permission to approach the witness with a receipt for the replacement of those barrels, Your Honor.
I do not object to that, Judge.
All right, go ahead.
Can I give these back to him, Judge?
Yes.
I'll trade you. Okay, there you go. Go ahead and review that for me.
Yep.
Having had the opportunity to review what I just handed to you, do you recognize that sheet of paper?
I do.
Okay, could you describe what that sheet of paper is?
It's the request for quotation from the guys, from the company that we bought the line from to replace the barrels that were destroyed.
Okay, so these are the barrels that went missing on the 17th of August, is that correct? Okay.
Yes or no?
Yes.
So did you, well, here, permission to approach, Your Honor.
Sure.
Your Honor, the people would move to publish proposed Exhibit A. This is that record indicating the amount that it would be to replace those barrels that were missing.
Any objection?
No objection, Judge.
So having contacted the firm seeking the replacement of those barrels, what is the number they quoted to replace those barrels? Let me start. How many barrels did you request?
Requested for three.
3 barrels, okay. And what was the quoted price for 3 replacement stainless steel copper barrels?
$67,240.
Okay.
And it wasn't copper.
I'm sorry?
I thought he said copper.
Stainless steel.
Stainless.
Yeah. Nothing further from the people that signed, Your Honor.
Well,
Good morning, sir.
good morning.
So I'm not really familiar with metal finishing, but it's my understanding that you use these barrels to put chemicals in and then put metal parts in there and stir them up. Is that roughly correct?
We put parts in the barrel and dip them in different tanks.
All right, so the metal barrel is there, and then there's a door that closes as you put the parts in there, and then does it get spun around to coat things? Is that correct?
No. Kind of, sort of.
Kind of, sort of?
No. So there are large stainless steel barrels that will put fasteners or light gauge stampings in. Okay. There's multiple barrels on a very large line, have very large tanks. In each one of those tanks, this is all part of the prep process prior to a coating operation, completely separate. So we're cleaning oil, debris, descaling. So they're dipping through a variety of processes
Okay, let
on
me ask
that
you.
line.
So,
And so each one of those barrels has, I don't know, upwards to 1,500 pounds or more of fasteners in it.
okay, let me ask you a question. So these barrels have chemicals in them and the parts are rolling around in them, correct?
The barrels do not have, I don't understand, chemicals in it. They have perforations that are dipped in chemicals.
Okay, so do these barrels wear out every now and then?
There are bolt gears on the outside that sometimes need replacing.
So how often do you replace these barrels?
Never.
Never? All right. So you're saying the barrels that were missing were barrels taken that were in operation at the time?
So occasionally we'll need to clean or repair. We have extra barrels. So if a bolt gear or a lid or a door or a fastener that attaches the door needs repairing, right? We have spares to be able to utilize.
All right.
We store those spares across the street.
So it was the spares that were taken from your business?
That are all part of a rotation. So if one goes bad, we have another to put in. When I say go bad, just needs a repair of sorts. But the stainless steel side of it never wears out.
Okay. I wanted to ask you about this invoice that the prosecutor just showed you. That was from Jessup Systems, you recall that? Okay, and it said it was $67,000 to replace things. Now, when I read the, do you still have that copy, sir? The last line of it, when I read it, it says the barrel
Wait a minute,
assembly.
was that yes?
Yes.
Yeah, okay, good. All right.
Smack me, Judge.
All right.
Wake me up.
Okay, the barrel assembly will have the cylinder mounted to a superstructure complete with hoist pickups and other gear assembly. So is it my understanding that this invoice is for an entire assembly, not just, the stainless steel drums?
No, so there are, bowl gears are just a big sprocket that attach to the barrel. They may have been or may have not been part of the ones that were missing. That I don't know.
Okay, but this invoice is not just for steel barrels, it's for the entire assembly. Can you confirm that?
There's not much to the assembly. It's just, there are two brackets that the hoist can pick up. It's nothing to do with the hoist. So it's very easy to switch out a barrel.
Okay, but my question is, the $67,000 is for, as this invoice reads, a superstructure complete with hoist pickups and drive gear assembly. That's all I'm asking you.
I don't know what he's saying. When we think of superstructure, it's the superstructure is something I have no idea as it relates to the barrel.
I certainly don't, sir. This is your industry, but.
I can't tell you on what they mean by superstructure. But the barrel itself has, the only thing I can say is gears and brackets.
All right, let me
in which the hoist picks up, and the hoist is not part of the barrel.
Okay, good, thank you. So you're saying that the spare barrels that you put out that were taken, they were just barrels, and there was 3 of them, correct? 3 stainless steel barrels?
Yes.
All right, that does not really represent what this $67,000 invoice represents.
It's pretty doggone close.
But this is for superstructures, those were used, these would be brand new, correct?
That's correct.
Thank you, nothing further.
Nothing further from this witness at this time, Your Honor.
Your Honor, I'm sorry, I did have one thing I forgot to ask with the court's indulgence.
Go ahead.
Sir, did you read the police report? Did you file an insurance claim?
No.
Okay, thank you.
Nothing further from this witness, Your Honor.
Thank you, sir. Thanks, Arnold. Oh,
Sir, your CREP process, CREP,
pardon me?
CREP process,
Name of it?
CREP,
I don't understand the question.
refer to the CREP process.
Correct?
That's okay, good.
Correct.
CR,
E-R-E.
CREPA.
No, prep, as in
CREP.
preparation.
Oh, okay, right. Okay, I found it.
Your Honor, briefly would recall Brandon Garside to the stand to verify the receipts received.
Oh.
The people recall Brandon Garside to the stand.
Mr. Yarside, you are still under oath, correct?
Permission to approach, Your Honor.
Yes.
Mr. Yarside, I'm going to hand you 4 pieces of paper. I want you to go ahead and take a look at those for me, and when you've had the opportunity to review them, please turn them face down and look at me. Having had the opportunity to review those, do you recognize those pieces of paper?
Yes,
What are those pieces of paper?
scrap receipts from Socorro Metals.
And those particular receipts, what days are on them?
The day that the,
Objection first, Your Honor, again, no foundation, I don't know whose receipts they are, what his relationship is to them.
Foundation piece. Going into what's on the receipt.
I'm sorry, Your Honor.
Instead of finish authenticating the receipt, I mean, just saying what they are is not authenticating them.
Understood, Your Honor. Does your name, your first name appear on those receipts?
yes,
What does that indicate?
that I was the scale operator who executed the buy of this metal.
So you, according to those receipts, and that matches your recollection that you were the scale
I
operator?
object to that as leading.
I didn't hear the question, didn't finish it.
I asked if that matched his recollection that he was the scale operators on those dates and times.
You just said that.
Understood. So, nothing further from this witness, Your Honor.
Sir, do you have any personal recollection of issuing those receipts? I mean, it was 2021, I'm just asking.
Well, I don't understand the question.
Do you have any personal recollection of issuing the receipts that the prosecutor showed you? Do you remember doing it specifically from 2 years ago?
Yes,
All right, so it's your recollection that you were the one that issued those receipts? It's not just because your name's on there?
yes,
All right, so you issued those receipts
yes.
yourself? Okay, nothing further.
Nothing further from this witness, Your Honor.
Thank you.
No further witnesses from the people, Your Honor.
I have no witnesses to it.
Your Honor, the people would move to bind over on only counts 2 and 3. Only the uniqueness of these particular barrels, given they were special.
What does that got to do with this man here? What do you have that says he did anything? What? I mean, that he did anything? That he touched something, that he did anything? What do you have?
Nothing on the record, Your Honor.
Then why? Okay, make your argument, I'll make my ruling. Go ahead.
Your Honor, at this point, the people would move to dismiss due to insufficient evidence.
No objection, Judge.
All right, now dismiss.
Thank you so much, Judge. Good to see you.
See you too.
Thank you, Judge Giles. I appreciate you in the honorable court. That's what I was trying to say this morning about that.
And I told him to dress up and he did a good job.
Yeah, you did a good job. Thank you. Appreciate it.
10.
You tell me. I never used to do anymore. Yeah, that's
Yeah,
Well, I just give it to you.
So
So the hourly work is either.
can I discuss like things like this with you?
It's coming back, no.
He claims that the investigation brief highlights on if he's not here, I go out there, he's mad because he claims he's retired.
Yeah, no, it's next.
He also told me to work in my house. He also told me to shrink his house. And then suddenly, over a year later, he says for sure.
All right.
I guarantee you. I mistakenly. I made mistakes too. And I
You're gonna make mistakes. You're gonna get the issue is. That's why nothing we just goes away.
So that, I'm the during here, yes, I think it's fair.
So that's why afterward.
Yeah. Yeah. I respected that. That was just really frustrating. I was trying to explain. I appreciate it.
Yeah.
I literally, that's my story.
Parties ready on Marcus Lewis. Calling case number 23-56155, the people of the state of Michigan versus Marcus Lewis. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. This matter is scheduled for exam. Defendant has failed to appear.
Good morning, Judge Alex Warren, on behalf of the people, appeal number P86590.
Good morning, Your Honor. May it please the court, Matthew Dupree, P80132, attorney for the defendant who is not present.
You have any contact with him?
I have not, Your Honor. I sent him a letter. I called and texted the number that he provided to MIDC. Never got an answer.
The people motion for papers.
Any bond previously submitted shall be for 30,000 cash.
Thank you, Your Honor.
Thank you, Judge.
Thank you, everybody.
That's all I'm right.
Yeah, that's it.